Something I'm asked pretty often is how to transfer real estate into a living trust. This is especially important for anybody that wants to transfer assets privately and out of the probate process and out of the public record. In this video, you'll learn exactly what needs to be done to transfer real estate into a living trust. I'll show you what it means to fund your trust. You'll see why funding your trust is absolutely essential. You'll understand how different types of real estate require different types of treatment. I'll show you why it's especially important to transfer real estate into a trust. You'll discover the most effective way to transfer real estate into a trust, no matter how it's titled. Now, at the end of this video, I've got a free gift for you, and you'll want to make sure that you stick around and take advantage of that. At the same time, make sure you like and subscribe to our YouTube channel to continue to gain access to this incredible information that we provide you on a regular basis. Okay, I want to begin by saying in order for a trust to become effective, it must be funded. Now, let's take a look at what I mean when I say funded. You may be thinking, well, in order for a business to be effective, it needs to be funded, meaning it has access to capital. It's got sufficient capital to operate, to meet needs, to do certain things. Well, with a trust, what we are talking about funding, I'm not talking about access to capital as much. What I mean is that the assets have been transferred into that trust. Because if we understand that the primary objective of a revocable living trust is to make sure that we accomplish our estate planning needs. And that means taking care of our family, transferring assets out of our name whenever we pass away, and making sure that they are then provided for the benefit of our heirs and beneficiaries. Well, that is accomplished through the trust outside of probate, but it has to be funded, meaning that we've got to transfer the assets into that trust before we pass away for the trust to be effective. Now, part of the reason for that is that only those assets that have been transferred into the trust are covered by the trust. There's something that we have to make sure that we do, and that is transferring title, transferring the name on the different assets, whether it's bank accounts, whether it's real estate, whether it's our personal property. All of this needs to be transferred as part of that funding process. Now, when it comes to real estate, there are certain steps that have to be taken because real estate has title. That title must be handled correctly or it's not inside the trust. And if it's not inside the trust, we don't get all the benefits provided to us by the trust. So again, we've got to make sure that we transfer those assets. Only what's been transferred in is covered by the trust. So this is a vitally important step in the overall process. All right, so I've made reference to this earlier, but to transfer title to real estate, we actually have to take care of transferring the title. Now, how that's done is a matter of the court records. We go to the county recorder's office and we file a deed. Now, with that deed, whether it's a warranty deed or a quitclaim deed, what we are doing is saying, I'm taking this property out of my name as an individual and putting it into my name as the trustee of my revocable living trust. That requires documentation. Now, there's not going to be any sort of transfer that's going to trigger any sort of a transfer tax, but there is going to be cost involved. And when I say cost involved, we're talking about a recording fee. Now, that's to the county recorder's office. And that fee is going to be relatively nominal. You know, typically when I take one to the county recorder in the county where I live, it's $25. You know, and that's going to be to make sure that we have the legal description, make sure that we have all of the legally required information that's in that deed and that it's signed, it's notarized, and then I take it down and I get it recorded and pay the $25 fee. $25 is not much, especially for the tremendous benefit that you receive by being able to avoid probate through this overall process. But it's something that you have to do. You've got to get that title transferred. Now, I may know what you're thinking right now, and if you're like a lot of people that I talk to, you're probably thinking, what about the due on sale clause? Now, when it comes to a due on sale clause, basically we have to think back with real estate. Several years ago, we had people that would assume mortgages. And this was a tremendous real estate strategy. If you had an assumable mortgage, basically you could transfer your property, somebody could just take over your mortgage, and that could be very beneficial for the seller, but especially for the buyer, because the buyer may say, hey, I don't necessarily have the credit worthiness to be approved for a loan. If I could just assume somebody else's loan, now I'm in business. And sometimes that worked out, and other times it did not. And because it did not work out in many instances, the bank said, hey, we've got to have some protection. We can't just have these mortgages that can be transferred to whomever the person that has the mortgage wants to transfer them to. So they said, we've got to have some sort of protection here. So they passed an act called the Garn-St. Germain Act that prohibited the transfer of these mortgages and authorized what's called a due on sale clause, meaning the banks now had the ability to say, all right, if you try to transfer your mortgage, we can call your note due. So you can't just put this burden on us that we did not willingly accept. Well, I understand that from the bank's perspective, but sometimes it can be abused. Sometimes if we're just transferring it into another legal entity, they could call the due on sale clause. One of the specific exclusions to the Garn-St. Germain Act is a trust. For estate planning purposes, if we transfer our property into a trust, it is an exclusion from the due on sale clause, so we're able to do that with no negative repercussions. Now that's great for your personal residence, so we'll just transfer it directly out of your personal name into the name of your trust. However, I work with a lot of clients who have rental real estate. Maybe that's what they do for a living, or maybe they just do that as kind of their side hustle, that they say, I'm going to just build wealth through real estate. Well, how do we transfer those assets in there? Well, you have to understand that with your personal residence, you typically get some sort of liability protection. Most states have homestead protection for somebody's primary residence, but they don't have that if it's a secondary residence. They don't have that if it's a rental property. So for those assets, we would utilize a limited liability company, or maybe even another type of trust that would be owned by a limited liability company to avoid that due on sale clause. Now, I know that gets confusing, so let me kind of break that down again. Let's say you had a rental property. Rather than just transferring the rental property into your trust, you've got no liability protection there. To get liability protection, we need to include a limited liability company or some other legal entity that provides us with limited liability protection. Well, there are a couple ways you can do this. One, if your bank, the lender, will allow this, you could transfer the property directly into the LLC, that limited liability company. Most banks have no problem with this because you are still going to be personally liable for the note. In the event that they do have a challenge with this, we could add an additional step and set up maybe a land trust, or what I sometimes refer to as a real estate privacy trust. If you transfer it into the trust, you would then have the beneficiary of that trust as the LLC. That's how you get your liability protection. So the great thing about this is we have options. And I got to tell you, in my opinion, life is all about options, business is all about options, and estate planning is all about options. The great thing about this is that we do have some options. If we do this where we transfer it into the LLC, we now have to make sure that the LLC gets transferred into our trust. We do that through what we call an assignment of limited liability company interest, to make sure that not only do we have the asset protection, but we also have the estate planning at the same time. Okay, now one of the questions that people ask me about pretty regularly is, what about properties that I may own in a different state? Well, it's a great question, because what I always point out is that if you end up having to go through the probate process, you have to go through probate in any state where you own property. So if you had rental properties, or if you have maybe a second home, or whatever you may own in other states, it's going to have to go through probate in those other states. It's what's referred to as ancillary probate. And that ancillary probate means not only do you go through probate where you live, you also go through it where you have that rental property, or have that second home, have that vacation home. Well, we want to keep that from happening. If you transfer this asset into your living trust, whether you do it directly or whether you do it through the LLC or the real estate privacy trust that I mentioned earlier, you're able to avoid probate, which is a tremendous benefit. Now, I got to tell you, I know that this information can seem a bit daunting. It can be a daunting task, which causes many people to say, you know what, forget it, I'm not going to do it. Well, let me just assure you, this is not difficult, but it is different. And because it's different, sometimes people think that it's difficult. I work with people on this on a regular basis, and I help them to accomplish their objectives. You know, we've talked about a lot of great information here in this particular video, but I cover so much more information in a mini course that I created called Enlightened Estate Planning, and I want to do something special for you. I want to make that available to you absolutely free of charge. That's right, you don't pay anything for this, but you do have to do something. You have to click the link below and you will be granted access to my mini course with incredibly powerful information that you need to know about Enlightened Estate Planning. Once again, click the link below to gain free access to that mini course to continue building this incredible information for yourself, but also for your family. I'm JJ Childers. Thanks for watching.